You raised a daughter with love, gave her wings to fly. But when it comes to property, does she have the same legal footing as your daughter-in-law? Or let me flip it. Your daughter-in-law cared for the family, supported your son. Does that mean she can claim a share in your property? The real battle over inheritance in Indian families isn't just about money. It's about love, law, and sometimes loyalty. In today's video, I'm going to break down what the law actually says about this emotional and complex topic. And trust me, by the end, you'll not only understand the law, you'll reflect on your own values and decisions. Hi, I'm Jerry and welcome to our Legal Life playlist where law meets real life in most practical ways. Check out the full playlist and the links are mentioned in the description below. If you are interested in protecting your rights or understanding your responsibilities, you're in the right place. Let's begin with what the law says about daughters. Before 2005, daughters had limited claim in ancestral property under the Hindu Succession Act of 1956. But the 2005 changed everything. It gave daughters equal rights as sons in ancestral property. In the case Vinita Sharma versus Rakesh Sharma in 2020, the Supreme Court made it crystal clear. A daughter is a co-partner by birth, even if the father died before 2005. So, what does this mean practically? If you're a daughter and your father has ancestral property, you have an equal right, regardless of whether you're married or not. Now, what about daughter-in-laws? Here's a legal twist. A daughter-in-law does not have an automatic right in her in-law's property unless it's her husband's share after a partition or if he had inherited and passed away without a will. Now, let's talk about a crucial legal turning point that reshaped how we view a daughter-in-law's rights. The case of Satish Chander Ahuja versus Neha Ahuja in 2020. In this landmark judgment, the Supreme Court of India held that a daughter-in-law has the right to reside in the shared household under the Protection of Women from Domestic Violence Act of 2005, even if the property is not owned by her husband but by her in-laws. This overruled the earlier understanding where the daughter-in-law could be evicted just because the house wasn't in her husband's name. The court emphasized that she has been living in the same home as part of her matrimonial life. She has a right to protection, not ownership, but residence. This case doesn't give daughter-in-laws ownership in the property, but it protects them from being thrown out unfairly. It's a reminder that even legal safeguards rooted in residence can offer dignity and stability, especially in emotionally and financially vulnerable times. Let me tell you about Sunita and Aarti. Sunita is the daughter of a farmer in Punjab. Her father passed away without a will, and her brothers told her that she has no share because she was married off. But Sunita fought back using the Vinita Sharma ruling and she got the rightful share. On the other hand, Aarti, a daughter-in-law living in her in-laws' house in Delhi, was thrown out after her husband's death. She filed a complaint under Domestic Violence Act and won the right to residence but couldn't claim ownership. This contrast shows why knowing the law is more powerful than just assuming traditions. In Indian families, emotions and obligations often overshadow legal rights. Many parents still write wills excluding daughters, thinking they'll benefit from their husband's family. On the other side, some daughter-in-laws become caregivers, taking care of aging parents-in-law and feel emotionally and morally entitled to a share. Here's the truth. Morality and law don't always align. But laws are changing and society is waking up. If you are a parent, you need to ask, am I being fair? or just traditional? If you're a daughter or daughter-in-law, ask yourself, do I know my legal rights or am I just hoping things work out? A practical guide, what can you do if you're a daughter? Don't assume you're excluded. Check if the property is ancestral or self-acquired. Ask for a partition if needed and don't feel guilty. You have a legal right. If you are a daughter-in-law, if your husband owns a share and he passes away intestate, that means without a will, you inherit through him. You have a right to reside in the house under the Protection of Women from Domestic Violence Act, even if you don't own it. But to claim ownership, there must be a legal transfer or inheritance. If you are a parent or elder, write a clear will. Don't leave ambiguity that creates family wars. Talk openly to your daughter and daughter-in-law. Fairness today avoids litigation tomorrow. So, who has more rights? Legally, a daughter has birthright in the ancestral property. A daughter-in-law has residence rights and conditional property rights through her husband. But beyond the law, the real question is, are we building families or fairness? Or just fear and tradition? Property disputes don't just destroy families, they destroy trust, love and legacy. You now have the knowledge. Use it wisely. Let's talk. Have you or someone you know faced this dilemma? Drop your story in the comments. You never know who might help. And if this video helped you understand something better, like, share and hit the bell icon. Because the law may not always knock twice. Want more practical legal insights like this? Subscribe and explore our legal life playlist, which is mentioned in the description below. Let's empower each other, one law at a time. Take care. Bye.